that whether it's the 92 million or whether it's the 24 million award of Judge Harms, it's about the same contract.
Well, if you want me to say it for the sake of saying it, I agree, we can move.
Okay. A reluctant yes,
It's not reluctant. I've
No,
already expressed myself
simple.
there. I
We're getting
agree,
stuck on
and I have
this.
explained the context so that the disinformation is not continuing. Council just referred to 92 million. Haram's judgment has got nothing to do with 92 million.
Yes,
92 million is the bid, the same panoramic contract bid camera, the 360 cameras, forensic services. When the contract was awarded on the 28th of July 2014, the value of that contract was 92 million. Now, it gets awarded. Once it is awarded, obviously, my environment, forensic services, is the end user because these are cameras that are used by crime scene experts. So ordinarily, we are to place an order and buy from that particular contract. That contract is awarded to Etemba. So before even we can place an order, a competing supplier, who in this case happened to be FDA, writes to supply chain management as a division, the place where contracts are being managed. They are the ones who awards and so on the contract. So they raise an issue with supply chain management, wanting to inquire on which basis was the bid awarded to Etemba, and say, indeed, they have looked at the specifications against the product that is offered by Etemba, and they concluded that that is not compliant with the specifications. In other words, supply chain management awarded to a bidder who did not comply with the specifications. I then write back to supply chain management to provide them with that information, to say, you have awarded a contract to a supplier, and we are not going to be able to use these cameras because they don't meet specifications, and publish the following. The issue there was that even the bid evaluation committee, when they made their submission to the BAC who awarded, they did indicate the non-compliance by the Etemba bid. Heavens knows why that contract was awarded, because the BEC is saying to you, this product does not comply with this thing. For example, one of the requirements was it must be a 360 camera. It must not allow manipulation. You must not stitch images together. But the Etemba product, you stitch, you do 90 degrees, 90 degrees, 90, which is, you now piece together the 90s to make it 360. Now that is unacceptable. You can't go to court and present such evidence, because the chances of the courts and Leonard friends arguing, but you have manipulated, and they are great. So that thing has got no value. Now, refused and say, we can't order this thing. We are not going to need it. I saved the department 92 million. That could have used to buy cameras that were never going to be used. In the submission, they say, can we take it for an independent assessment? 23 November 2016, I agree and say, take it for an independent assessment. I think also there is an email here where the same supply chain management people communicate within themselves and say, the acting national commissioner said we must defend the litigation, take it for independent assessment. But I can tell you that today it is not dealt with. So when we talk about 92 million, you are not talking about 92 million in respect of Haramse. You are talking 92 million in respect of the July 2014 contract. Now, I'll repeat it here. I refused to order from that contract because the experts were never going to use that camera. Beyond me, remember I say I signed and approved that the independent assessment must be done based on the advice of National Treasury also. Even us as forensic services, there is a letter there, 29 April 2016, which is saying, take it for independent assessment and we will pay. In other words, forensic services was even prepared to pay for the independent assessment. To date, it did not happen. Come the 1st of June 2017, I'm out of office. Having directed that you must still do independent assessment, defend the litigation, because at the time there was an email from Etemba saying, we now want these, they were now demanding 14 million to say, because you did not order for our damages to bid and so on, pay us 14 million. I don't know what happened, because since the 1st of June 2017, I'm involved nowhere. They go on, then there is a settlement, which is signed by General Setole to say, let's settle for the no more than 14 million. When I was in office, I saw them asking for 14 million, but they settle to pay 24 million. Now, I don't know how long it took to settle the 24 million, because there is 7 million extra that they paid for interest. Now, Honorable Chair, my question is, I'm not going into the merits of the dismissal or whatever. My question is, what do I have to do with payment that was settled by General Setole in 2018, 2019, when I'm long out of office, despite the fact that everyone consistently in forensic services was opposing and saying, we can't pay. No one of forensic services was involved in a litigation, deliberately excluded. And when they pay, after they paid, that's when they come run into me and say, you cost the state 24 million rand loss.